Good to go.
Good morning. This is a convening of the Massachusetts Gaming Commission. We are holding a public meeting today and we're doing so virtually. So we will take a roll call. Good morning, Commissioner O'Brien.
Good morning, I'm here.
Good morning, Commissioner Hill.
Good morning, I'm here.
Good morning, Commissioner Skinner.
Good morning.
And good morning, Commissioner Maynard.
Good morning and happy birthday, Madam Chair.
Thank you very much. It's been a busy early morning, so thank you. That's very nice to be on this planet today, so thank you. But we have really a big meeting today. It is public meeting number 469, and before we get started, I want to first thank the legislature and Governor Healy for signing the law that allows simulcasting parimutuel wagering and racing to continue today. And we wish all the athletes, that includes the horses, good luck today as races continue here in Massachusetts. So that all happened seamlessly, and want to thank Commissioner Hill for all your work and Grace Robinson for her work, and of course, Dr. Laybound for her work on managing that process. So thank you. The other thing I want to acknowledge is today is the 1-year anniversary of sports wagering becoming law. It's been a very busy year, and I want to, on behalf of all the commissioners, I know we continue to extend our gratitude to all of the team for all of their hard work to stand up sports wagering in a timely fashion that also preserve the integrity of the gaming community and gaming industry here in Massachusetts. And we thank everyone's efforts to always keep in mind the importance of consumer protections and responsible gaming really at the forefront of our minds. So thank you for that. And I think those are all the announcements, except it's also the anniversary of Commissioner Maynard's appointment. A lot happened last year on this date, and Director Lilios and I were reminiscing on it. So it was a busy year, and now we continue to do important work for our applicant before us today. So we'll turn to the matter at hand. I'm calling to order, as I said, public meeting number 469. And you'll see that the agenda is a continuation. We have met twice already on this matter, and it has to do with the application of Massasoit Greyhound application. We refer to it either as MGA or, of course, Raynham Park. And as noted on our agenda, we met on June 12th and June 20th. And I'm going to turn it over now to our interim executive director, Todd Grossman, but in this case, in his capacity as our general counsel, to remind us of the legal framework, and then we'll continue on. Commissioners, are you all set? Is there anything you want to add this morning? All set. All right. Thank you, Todd. Good morning.
Thank you. Good morning, Madam Chair, commissioners, and to the applicant, members of our team, and all who are joining. The commission, of course, as the chair has already noted, is scheduled to continue its evaluation today of the application of the Massasoit Greyhound Association Incorporated's application for a Category 2 sports wagering license. You'll recall, of course, that a Category 2 sports wagering license, as it pertains to the present applicant, is a license issued by the commission that permits the operation of sports wagering in person on the premises where the licensee is authorized by law to conduct simulcast wagering on horse or greyhound racing, and through not more than one individually branded mobile application or other digital platform approved by the commission. Additionally, as it applies to this application, Chapter 23N provides that the commission shall issue a Category 2 license to a Greyhound meeting licensee that conducted simulcast wagering as of December 31st, 2020, as authorized by law, that meets the requirements of Chapter 23N and the rules and regulations of the commission. And as was noted, the commission commenced its evaluation of the application on June 12th of this year and continued that evaluation on June 20th. It reached a general consensus as to the evaluation of many, but not all of the factors outlined in the regulations. The remaining areas to be addressed pertain first to the preliminary suitability of the applicant and its qualifiers, including overall and financial suitability. And next, at the request of the commission, MGA has also provided supplemental information pertaining to its willingness to foster racial, ethnic, and gender diversity, equity, and inclusion. Accordingly, today there are several items on the agenda for your consideration. First, on July 27th, which was this past Thursday evening, MGA submitted 2 written requests for withdrawal of a qualifier. The first request is for the withdrawal of Christopher J. Carney as a qualifier to MGA. The second, which is a related request, pertains to the withdrawal of the Christopher J. Carney Subchapter S Trust as a qualifier to MGA as well. Both requests for withdrawal have been provided to the Commission. So the Commission's first order of business this morning may be to decide the order in which it would like to address these requests for withdrawal. This is a procedural question at this point and not related to the substance of the request, but at this juncture, only the order in which they will be heard and addressed by the Commission relative to the continuation of the review of the application that is before you. Prior to making that decision, I would propose that the Commission hear both from the IEB and counsel to MGA and Mr. Carney regarding their positions as to the ideal order in which the withdrawal request should be addressed. At that juncture, the Commission can determine how best to proceed today. As always, of course, the legal department is here to address any legal questions that may arise as part of that discussion. If the Commission is so inclined, and after that first issue is discussed, the second item on the agenda concerns presentations and analysis relative to the Commission's review and evaluation of MGA's application for the Category 2 sports wagering license. And specifically, the Commission may choose to move forward with hearing information concerning its preliminary suitability and preliminary financial suitability, one of the areas where it left off last time. And then the third item on the agenda concerns the Commission's review and evaluation of MGA's application in accordance with Section 218 of our regulations, which includes but is not limited to consideration of the familiar evaluation factors. The Commission may address any of the factors listed in today's agenda, including but not limited to reviewing supplemental materials that were provided by MGA concerning, again, its willingness to foster racial, ethnic, and gender diversity, equity, and inclusion. You'll recall, of course, that I reviewed the applicable standards and legal principles related to the applications for Category 2 sports wagering licenses on June 12th at the outset of this hearing. I'd certainly intend to review them again, as we have customarily done prior to your final deliberation in this matter, but would of course be happy to address any of them now or at any other point in these proceedings as it would be helpful. With that, Madam Chair and Commissioners, happy to take any questions, but otherwise I'll turn this back over to you to inquire of the IEB and applicants or proceed as you would otherwise like to do.
Thank you. Any questions at this juncture for, we'll say, General Counsel Grossman in his role today? Commissioners, are you all set? Okay. So we've had the opportunity to receive and review documentation regarding the request for withdrawal from MGA with respect to an individual qualifier. And we've been asked to consider the order of our decision making. So as General Counsel Grossman indicated, we would probably benefit in that decision making by hearing from both MGA and legal, and I assume that would be in concert with IEB. Does that make sense, Commissioners? Is that how you'd like to proceed? Okay, I think I saw absolutely. All right, Commissioner Skinner, you're in agreement. So is there, I'm going to turn to Attorney Nozel. Thank you for your submission. I don't believe that there's a set order, given this is a procedural matter, but I want to defer to you. would you like to respond to IEB and legal? You'll have the opportunity to respond in any case, or do you wish to go first, Mr. Nozel?
Thanks, Chair. I'm happy if we're limiting this, I guess, initial discussion to the, I guess, order of presentation today. We were under the impression first and foremost that we're going to proceed as the agenda sort of set out. I understand the commission has discretion to do that. I'm happy to give some rationale behind sort of the process as some initial remarks on this. Or, certainly if the commission wants to hear sort of the full presentation on the request to withdraw, we're happy to do that as well. And I'm happy to do that first, with the understanding I'd like to reserve to respond to any comments or issues that the IEB or legal team raises.
So I think the narrow question right now is, as I understand it, is that these requests have been made. I believe that IEB would prefer that we not substantively, and Director Lilios, you're going to jump in if I mischaracterize it, would say that we might consider the substance of the request after continuing on preliminary suitability report submitted by IEB. It's my understanding that your preference would be to go forward on the request first before our review of the IEB report. And so if it would be helpful to give us some guidance on just the order of our consideration, that would be a starting point, and then we'll decide if we go further into substance. And I'm turning to legal now for help.
I think that sounds exactly right. So yes, I think if Mr. Nozel and or his I don't know if Mr. Maurizio is available here today too, but if either or would like to address that, I think that would be helpful. And then of course we could turn to the IEB to get their position after that.
Sure, I'm happy to make some remarks about the process and I guess the sequencing of the commission's decision making. And Chair, just as a matter of housekeeping, I just did want to introduce sort of who's in the room
Thank you.
today. Obviously, not everybody is on camera at the same time, so we have many folks who have been, before the commission in connection with this application previously, including Mike Michno, Joe Capucci, Dan O'Brien, Bob Brooks. As Attorney Grossman indicated, I'm joined today by Attorney Maurizio on behalf of Christopher Carney. We have Christopher Carney, we have George Carney, and of course we have Sue Rodericks and Kevin Regan.
Thank you, Attorney Nozel, for that.
Yeah. So in response to your specific question about the sequencing and how the commission ought to proceed here, first I think we need to look at the regulatory framework that we're within, and clearly in connection with the commission's regulation pertaining to a request to withdraw, it allows that to happen at certain stages. In some cases, it can be done without commission review, and other stages it is required for commission review. So in this particular circumstance, because of where we are in the process, the commission's regulations as part of the deliberation of preliminary suitability require that the commission approve the request for withdrawal at this stage and based upon good cause. I think just from a process perspective, the determination of the ending scope of your review of preliminary suitability is going to be completely determinative on really whether you grant the request to withdraw or you hold them in abeyance or you decide to rule on them in another way. That will then formulate exactly what is before you in determining preliminary suitability. So to me, both from an efficiency standpoint, from a a standpoint of really focusing the commission on the decision that it has to make, the determination of whether or not these two qualifiers, and again, that's the Christopher L. Carney Trust and Christopher L. Carney, should be part of the application, is to me a gating issue and really one that ought to be decided and reviewed at least prior to the commission's determination on the preliminary suitability of the applicant. And I'm not sure, Attorney Marzio, if you have anything to add in connection with that.
No, not at this time, thank you. Other than to say good morning, Chair and members of the commission and staff. My name is Michael Marizio. I'm counsel to Christopher Carney.
And good morning, and thank you for your guidance, Attorney Nozel. I do need to correct it because I think I may have said a request for withdrawal, and of course it's two requests, both for the entity, the subchapter S trust, as well as the individual qualifier. So thank you. Now I'll turn to Director Lilios. Good morning, Loretta.
Hi, good morning, Chair. Good morning, Commissioners. I do have some input on this question of process. My comments are kind of robust because it is an important matter. So I will be mindful that we are, talking process here and not substance. And I fully understand that Mr. Christopher Carney and the subchapter S Trust should have an opportunity to present their request to withdraw their applications for this license, and agree with Attorney Nozel's citation about our regulation 213, that this withdrawal question, because of the posture of where we are now, is a matter for the commission. Our regulation says that once the applicant requests a hearing, it's the commission that decides on any withdrawal requests. And here, not only has the applicant requested a hearing, the hearing's underway. This is the third day of the hearing. Just like the applicant should have the opportunity to present its requests, the commission as well should have the opportunity to be prepared on these requests. And the IAB received these withdrawal requests after business hours on Thursday. They were forwarded to the commission last Friday morning at a time when the IAB was preparing for the presentation on preliminary suitability. And I expect that the commissioners were reviewing the IAB's report and the lengthy exhibit materials that were also provided. And we've gotten additional documents from the applicant in support of the withdrawal requests on an ongoing basis, as late as this morning, I believe. And under the regulation, the commission will have to evaluate whether there is good cause to allow those qualifiers to withdraw at this stage in the process. They are, as I said, important requests. I believe they're deserving of a substantive written input from the IAB. If the commission would find it helpful for the IAB to respond in writing, we can do that in a reasonable period of time. If you think that would be helpful to you in deciding the withdrawal requests. I do have more comments on why the withdrawal request should not be considered in a vacuum, and why they should not be considered, as an initial matter. So if you'll allow me, I'd like to try to shed some light on that, if you think it would be helpful, Chair.
I'm going to turn to Councilor Grossman because I want to make sure that, again, I know that Attorney Nozel can respond, but are we delving into the substantive area more than process? Is this really about the order? I just want to check in with you, Todd, on this, because I know Director Lilios wants to get it just right as well.
Yeah, it sounds like it's certainly related to the process. I think certainly Attorney Lilios and Mr. Nozel are kind of aware of the commission's interest at this point in just, setting forth the process. And there will be time, of course, to talk about the substance of it. But if there's a little bit of overlap just for textual purposes, I think that is certainly appropriate at this juncture.
Okay, then I'll proceed, Chair.
I'm not hearing any objection from my fellow commissioners. Are you all comfortable?
Chair, obviously, I don't know sort of what Director Lilios is going to sort of present now, and I'm not objecting to it, but certainly want to reserve my opportunity to respond. And again, I thought we were talking specifically here just about what's in the commission's interest, or in the applicant's interest, and what will work for the IEB as just to the order in which this gets presented. And I've limited my initial comments to that, not getting into anything regarding cause, not getting into anything regarding any substance of the request for withdrawal. So I just want to make sure that we stay within the parameters of the way the commission is setting up this initial discussion.
Right, and Director Lilios, did you say that you need to add context for the purposes of us understanding the request substantively, or to understand order?
The latter, order.
And also, Director Lilios, I know that you are aware of the regulation. I think that Councilor Grossman can advise us on should the applicant wish to have any kind of go into executive session pursuant to a regulation, you would honor that as well, correct?
Yes, of course.
Well, I'm not seeing any objection to Director Lilios's desire to go forward, and I know that you're quite aware of Attorney Nozel's request just now. And Attorney Nozel, if you have any concerns, please, don't hesitate to raise them as we go along. And you're comfortable with that, correct, Director Lilios?
Yes, Chair.
Great. Thank you so much.
So there have been written withdrawal requests submitted. And so I'm drawing on information in those withdrawal requests. And in terms of process, those requests make it sound like the withdrawal question is entirely separate from the question of the applicant's preliminary suitability. And the withdrawal requests, the written withdrawal requests, ask you to cut out those qualifiers, and then you would look at the applicant's future suitability. What does the applicant look like moving forwardly, prospectively, without those qualifiers? But the commission should not consider those qualifiers withdrawal requests in a vacuum, because those qualifiers are relevant to the suitability of the Massasoit Greyhound Association, this applicant, and the other qualifiers in this application. There is talk in the withdrawal requests about a trust that's been referenced already in this hearing. But Mr. Christopher Carney's ties to MGA are not limited to that trust. Our preliminary review shows that his ties do run long and deep to this applicant. The applicant is a closely held family company. Although Christopher Carney does not have an official job title at MGM, he has been integrally involved in that company for years. He's held himself out as representing the company at the highest level. He's been involved in the construction through his construction and trucking business of the actual construction
Director, I'm sorry, I don't mean to interrupt, but this to me goes to the heart of the request to withdraw, which we haven't presented yet. We're, Chair, we're just, again, talking about whether the commission should consider this before or after. I understand the IEB's position, meaning that they ought to be considered together. But now we're, essentially, I guess, arguing here, and what's being presented somehow is that, potentially the request shouldn't be granted. So I'm a little bit concerned that we're getting beyond sort of the scope of this initial sequencing discussion. And I say that respectfully, Director. I'm not, trying to cut you off. I'm just trying to keep this part of the discussion focused.
Thank you, Mr. Nozzo. Councilor Grossman, I do want to make sure that if there are points that Director Lilios is making that do sound substantive. In fact, is this the right time for her to make those points, or is there a better time, given that we are talking right now? Should we move on the request?
Yeah, I think that we do want to just kind of stick with the process. And I think Ms. Lilios has made the point as to why she believes that the requests perhaps are not ripe for decision today. And I think we've covered that now. So I think we should probably kind of stick to just the process at this point.
So, commissioners, I do want you to weigh in here. This is complicated, but I think the core question is right now before us. Do we hear the request for withdrawal in advance of hearing the IEB report that's been prepared by IEB on preliminary suitability, and that of course includes some of it, supplements on financial suitability? Do we hear the request first? And what I guess, Director Lilios, could you answer the question? And I don't know the answer to this question, so I'm asking one. Could you explain to the commission why the order matters without getting into facts? I think I heard you say because the withdrawal shouldn't be determined in a vacuum. And if that's one question, my question would be, and maybe my fellow commissioners have questions for you on that point, wouldn't you introduce those facts substantively at a hearing or on the withdrawals themselves?
Yes, there is overlap in those facts because the issues identified in the IEB review reflect not only on Christopher Carney, but they reflect upon the applicant and all of the qualifiers in this report, including the statutory suitability criteria.
Any questions at this juncture for Director Lilios? So one rationale is not to consider it in a vacuum, and theoretically you could bring the facts in that are necessary so that, as you cited, just started to cite for us. Is there another rationale for the order question? And thank you.
Sure. The commission asked the IEB to perform a preliminary suitability review of this applicant and to supply a report on this preliminary review to you. That's consistent with our regulations. That's what our regulations directed. We have done that. We did the preliminary financial suitability review. You had a report and 2 supplements on that, and you have the general suitability preliminary report that you got on the 17th. Only after that review was performed and you got the report or the request to withdraw brought forward. That report is done. We have done everything that the regulations and that the commission has asked us to do, and we have given you a full document with supporting exhibits for that document. And that is before you now. And to move forward with withdrawal as entirely separate from that report ends up changing the report. The applicant would look like a different applicant. So I understand that the applicant should have the opportunity to present these withdrawal motions. The qualifiers should have that chance to do so. But the issues that are causing the qualifiers to ask for withdrawal are integrally tied to the suitability review that was already performed. And that is a completed preliminary report that is before you, and that I suggest, in consistent with the transparency principles that you have always operated by, it is something that should be reviewed by you as scheduled today. I'm not suggesting that you vote on preliminary suitability today. I'm suggesting that you look at what the IEB already did, and then you look when you can be better prepared and hear from the IEB if you want to at the withdrawal request, and then decide those two matters in one comprehensive decision.
Attorney Nozel, do you want to weigh in, or commissioners, do you have questions before he does?
I defer to the commission's questions, but of course, I do have a few points that I wanted to make, Chair, if that's helpful.
I did, Chair, there are some other instances where the commission has decided withdrawal requests in the past. If it would be helpful, I can touch on those. There are 3 instances that come to mind. Would that be helpful?
Could we hold on that just so
Yep.
that Attorney Nozel can respond to your most recent comments, and we'll go to Attorney Nozel and then commissioners. We'll make it a little bit of a flexible back and forth. This is not an adjudicatory hearing. I want to point that out. So we have flexibility to hear from each other. Okay, go right ahead, Attorney Nozel.
Okay, thanks, Chair. Just a couple of things in response. I think what's being attempted here in connection with the application is to remove 2 qualifiers that the IEB report has raised questions about, which we feel will be difficult to address in a preliminary suitability determination. The request to remove those 2 qualifiers doesn't insulate MGA and the remaining applicants from questions that are raised in connection with the IEB report pertaining to a relationship or no relationship with certainly those entities that we're asking to be removed. In addition, I do want to point out, and it's documented in the materials that have been presented to the commission, we have been talking about removal of Mr. Carney for probably over 2 months now. The impetus for the change that we've now made, which was one that comes without, which was significant, and I won't get into the details at this point, was the issuance of the July 17th report, which again, we felt it was in the best interest of the applicant for the Category 2 sports wagering license to make a change in the interest that was triggering the requirements for the trust and for Mr. Carney to be part of the application. As to the timing of that, again, we did that, and I don't want to be in a position of putting sort of words into anybody's mouth, but once we made that decision, we did inform the IEB that we were taking those actions. And I don't remember the particular date, but it was, I think, at least within a week of the report being issued. It took a while to document and make the changes that we needed to effectuate, the basis for our withdrawal. So again, I just don't want to act as if the request to withdraw Chris Carney is a new issue. It's not. It's been at issue for a long time. Our preference certainly would have been to have this done under what we believe the discretion that the IEB had in order to remove Mr. Carney. They disagreed with that, which essentially necessitated this being decided by the commission. And we've moved as quickly as we can in light of the report in order to make those changes. And again, from our perspective, the commission should have clarity of what it's reviewing for preliminary suitability prior to getting into those deliberations. And I'll stress one more time as I finish, it does not insulate MGA from having to answer any questions that pertain to the trust or to Mr. Carney as they relate to the MGA application going forward.
Commissioners, questions at this juncture?
Chair, can I
Commissioner
respond?
O'Brien?
No, I have more comments than questions. So if Loretta Lilio says something else to add, maybe it's not the time for the comments.
Thank you, Commissioner. I did just want to respond because it is absolutely correct that the applicant requested weeks ago to withdraw Christopher Carney, and that request went to the IEB before the matter was scheduled for hearing. The basis for the withdrawal at that point was entirely different than the basis for the withdrawal that's presented to the commissioners today. The basis for the withdrawal at that time was, he would not be involved in any future management role. Subsequent to that, as late as mid this month, there was a significant role that he played in a significant piece that's probably better reserved for executive session. But just in terms of the IEB's awareness of withdrawal request, there was one made to the IEB weeks ago. I think it may have been in May. We declined to disturb the designation as a qualifier at that time because we felt it was a statutory requirement that Christopher Carney remain a qualifier. But I did want to emphasize that what was recently submitted as a basis for the withdrawal is not something that was before the IEB when that request was made.
Director Lillios, can I just clarify? You're not saying that you just learned, IEB just learned of the basis for this withdrawal on Thursday. The writing came in on Thursday, but when did you actually have conversations with Attorney Knowles? I just want to make sure we're very clear that IEB was considering that.
Yeah, it wasn't that much earlier than Thursday. Initially, when the IEB received the request, I think back in May, the IEB asked about this other basis for withdrawal and whether that was something that the company was willing to do. And we were told, no, that was not on the table. And, now that is the basis for the withdrawal now.
Chair, I'll just respond quickly again. I don't think Director Lillios and I are in disagreement about the substance or the steps that have been taken here. I think we, in connection with the previous request for withdrawal, there was a discussion around taking an additional step that we've now taken. We weren't comfortable doing that at the time, obviously, without the benefit of the report. And it was really once we had the report and understood what was going to be before the commission and how we were going to navigate that, that we made the decision, along with Mr. Carney and the trust, to withdraw those applications. So just for context in the sequencing, and Loretta, again, I'm not, excuse me, Director Lilios, I'm not, I believe we had a conversation, I think it might have been the Monday after the report was issued, about the steps we were going to take. Again, that would have been just 2 or 3 days before we actually filed it.
Okay. Now, Commissioner O'Brien.
So it seems to me like IEB was prepared to go forward to present on the report that's been in front of us. And there seems to be a representation from IEB as well that the motion to withdraw as a qualifier is somewhat integrally intertwined with the information that's in that report. So it would seem like the logical progression would be we go forward today with that presentation. We can also hear presentation on the motion to withdraw from Chris Carney and the trust, but it also sounds like IEB is asking for the ability to put something written in response in front of us. So it would seem like continuing to move would be hear the presentation that we were queued up to hear. We can also, if they want to go forward with the presentation on the motion to withdraw, but I would also want to give IEB time to put anything in front of us in writing in short order that we could then come back and decide if we're going to either move on preliminary suitability and or the motion to withdraw. But it seems like we could keep the ball moving by going forward with IEB's presentation today.
Okay, Commissioner Maynard, Commissioner Hill, Commissioner Skinner. Oh, Commissioner Hill? I don't know which one first. You choose.
I think Commissioner Skinner beat me to it, so by all means, I yield.
Thank you, Commissioner. Thank you, Chair. I understand the assertion that these two matters are overlapping. And I want to lend support to Commissioner O'Brien's suggestion that we hear what we were expecting to hear in terms of what had been teed up today, but then additionally to allow the applicant and IEB, to the extent that they can, to present their positions on the withdrawal petition. I say I can relate to the statement that we should not be looking at these matters or the preliminary suitability matter in a vacuum, because on the one hand, if I were to decide preliminary suitability today without consideration of the withdrawal petition, I might have difficulty finding in the affirmative. But on the other hand, it was already mentioned, just having received the withdrawal petition on an additional basis, I don't feel I have the benefit of an understanding of IEB's full consideration. I'm aware that there were prior discussions between IEB and the applicant relative to the withdrawal request. We have the materials in the exhibit packet, but all I have in terms of a response from IEB in that written material is the declination to accept the withdrawal. So I would like the benefit of additional information and briefing on that question. Thank
Commissioner
you.
Hill?
I agree with my fellow commissioners, Madam Chair, on this issue. I would like to get further information from IEB on the request for withdrawal petition, and I would like to move forward with what we had previously thought we were going to be debating today, which is moving forward with the application. So in my humble opinion, IEB information needs to be put before us. We need to give them some time to be able to do that. And then I would like to move forward with the application today as we thought we were going to be doing a few days ago.
Commissioner Maynard?
I hear what the applicant is saying, so I want them to know that I hear them. But this cannot be decided in a vacuum. And I agree with Loretta Lilios on that point that we can't unsee what we've already seen. We do have to do everything in public. It's a part of what we do. I don't want to make a decision in a vacuum and then have that decision disturbed. I think seeing the full field and then making a decision is what I have to do by the regulations and the statutes. So I feel like my hands are tied here. We do have to look at this and look at it in full.
So I'm going to present another alternative just for everyone's consideration. I did hear and thought a lot about this because of just figuring out our agenda today, right? And I worked, thank you for your help, both Attorney Grossman and Attorney Monahan on that. And we could, as an alternative, because these withdrawals in writing came to us on Thursday, we could ask IEB to respond, to prepare something. And she did say, Director Lilio said she could do that in relatively short order. We would give IEB the amount of time needed. And in many ways, and I would make the suggestion that, of course, we cannot decide the withdrawals in a vacuum, but much of what is in the IEB report could be incorporated fully into the withdrawals. The withdrawals that would allow, I take very seriously the point that Attorney Nozel made, that this would not insulate MGA in any way with respect to its assessment of suitability should the withdrawals be granted, that we would then be able to focus on the applicant in an efficient, and I heard Attorney Nozel mention that, an efficient process, and focus on without distraction, should the withdrawals be granted, without distraction about the two entities that are no longer qualifiers. Quite honestly, I'm having a hard time from a practical and intuitive sense about going forward, assessing the preliminary suitability report, knowing at the end of the day, how do we do that if in fact we haven't determined whether two of the qualifiers that are very much a core piece of the preliminary suitability report we haven't determined if they're in or out. I just think from a practical point of view, we could roll it over. I am aware of that time is of the essence. But I put that out as another consideration. We come back in short order and Director Lilios and IEB responds to the request for withdrawals. Now, I do know that Director Lilios is going to inform us of that we had, I think, 3 decisions where this issue came up. We haven't had this issue come up under 23N and the preliminary suitability, but we could hear on that. If in fact none of you wish to entertain that, then we don't really need to go on. But I also have one last note. Our regulation allows for a notice of withdrawal to be given. And I know that in many cases, we would pause and hear that. And I know, yes, we're ready to go today, but I just wonder, and perhaps MGA, Raynham Park, you'll say, no, let's go, let's move forward. And you don't want to have to pause to allow for IEB to respond to the notices. But I am not uncomfortable pausing altogether to allow for the opportunity to address these issues of efficiency, practicality. And then there's also the issue around order. Can we do this in a public meeting and not address the withdrawal in an adjudicatory hearing first. You know, that's a concern of mine. Should we, and maybe I could ask Councilor Grossman, would we be hearing the withdrawal request in an adjudicatory hearing setting, or would it be a continuation of this public meeting? So I throw out that as an alternative process for your consideration.
Madam Chair, if I could
Yeah.
respond.
Sure.
I appreciate your suggestion. A pause is my most preferred way to deal with these issues. I did not want to suggest that out of respect for the applicant who is appearing before us now, day 3 on this application for a Category 2 sports wagering license. I think that, you know, to your point, that's the most efficient way to deal with this, because already, you know, it's been 2 days, and at some point, it's going to be a little bit of information overload, and it is difficult to keep up with all the facts and the documents. There are many. If the applicant would be amenable, I would support, Madam Chair, your recommendation or your suggestion to postpone these proceedings in their entirety so that we can have an opportunity to more fully review the issues as a whole.
Can I ask, just insert one clarification? My suggestion would not be to come back where we are today. My suggestion would be if it's amenable to the applicant, because I am mindful, like you, Commissioner Skinner, of time being of the essence, in short order coming back and then turning to the request of the review of the withdrawal, and turn to that with the information, you know, incorporated everything that Director Lilios needs to make us really well informed on that decision based on what has come in writing to us on Thursday night.
Thanks for clarifying that. But then I would not expect any decisions to be made today on preliminary suitability. Is that?
That's what I imagine.
Okay, excellent. Thank you.
So I have 2 concerns with that. One is I do think procedurally we're in a posture to go forward with the report as it was presented to us. And I have some issues with not moving forward with that and then prioritizing the withdrawal motion given the context. And I appreciate also the representation MGA would still be subject to continuing cooperation. However, Chris Carney himself would not be. Given the integral intertwining of those 2, that gives me pause to move forward with the motion to withdraw before we hear substantively on suitability. The other concern that I have is really an internal procedural issue, which is Director Lilios leaves us in a couple of weeks. And so not only the applicant wants to move forward with this, but we structurally, I would like to get as much off of our plate and IEB's plate as possible before the end of August, particularly the 24th. So I would still, I mean, and I defer to IEB and to Loretta and Kathleen, but I would like to hear from them in terms of timing as well, because we do have our own internal issues in trying to move this forward.
Well, I'll respond to that. I understand Director Lilios's schedule, and I know that there's quite a schedule in August for all the commissioners. I just want to, and Director Lilios, I know you appreciate this. I do feel that IEB and all of her divisions will be able to address this matter. You know, I think because it, you know, if it continues through her date of departure, I mean, we have to operate that way, right?
Madam Chair, I'm not implying that they can't. I'm just being realistic on the ground in terms of trying to move everything, not only this applicant, but the business the commission has at hand moving forward.
Yeah.
So I stand with sort of my original request for how we proceed today, is move forward as much as we can. but I defer to IEB and what their response is to your suggestion.
Okay, thank you. And I just want to turn to, I think Commissioner Skinner raised an important point about how does the applicant feel about the alternative? If there were a date, I don't know, Grace, what would be the date that theoretically we could come back on?
So commissioners, please correct me if I'm wrong on your calendars. I believe next week, a number of folks are on vacation. So we'd be looking at the week of the 14th. I know early in the week, some folks will be traveling, going to a conference as well. There is an agenda setting meeting on Wednesday, August 16th. We could tack onto that meeting. Would probably be the earliest date, but Commissioners Maynard and Hill, I'm not sure if that will work for you all.
And then is the 17th, we have a public meeting on a bunch of other things. And then what about the 18th?
The 18th does appear to be available. It is a Friday, but the Friday, August 18th does appear to be available as well.
Right. And I don't know if we've gone back to next week, but I think IEB needs time, would need time to prepare. So, but now can I turn to Director Lillies, do you want to weigh in now?
Yeah, sure. Thank you. Thank you for the opportunity. And, certainly the IEB, it is the IEB's preference to move forward with what we can move forward on today. I have absolutely no doubt that the IEB will be in excellent hands once I move to the next step for myself. But nonetheless, this has been a significant body of work that we have already completed here. And we are also faced with, as you well know, a significant body of work with the other full investigations on the category 3. So it's definitely the IEB's preference to move in a forward motion on what can be accomplished today. And I am a little concerned that we paid a lot of attention to me not talking about sort of substantive matters in my presentation. And I, fully understand that this is a process question, but I want to make sure that the IEB has the full chance to put forth its view on why moving forward today is actually a time-saving piece. And I do think that those prior decisions of the commission may be helpful in further rationale for moving forward on preliminary suitability today. So if you think that would be helpful for me to speak to those cases, I'm happy to do that.
I'm going to turn to Attorney Nozzle. It looks like you might be prepared to respond, or?
Sure, a couple of things. First, I just wanted to turn to Attorney Maurizio to address an issue that Commissioner O'Brien raised regarding Christopher Carney's availability or participation in the process going forward.
Yes, I would like to assure the commission and the IEB that even if Mr. Christopher Carney is allowed to withdraw in his trust, they will, the trustees of that trust and Mr. Carney, Christopher Carney, will be available and will make themselves available whenever the IEB or the commission requests. And the fact that he's no longer a qualifier will not stop his participation in this process if that participation is requested by the commission or IEB. So I think that's important to put into the record. The other thing I'd like to say is there may be a little bit of confusion over the request for withdrawal. We believe respectfully that is a very discrete issue. We fully recognize that the commission is free to explore whatever questions it may have with the applicant, but the legal standard for withdrawal as to the trust in Mr. Christopher Carney is a very specific and narrow question. And we have tried to put forth the papers, and we're happy to talk about them today, which demonstrate that Mr. Christopher Carney and the trust have absolutely no financial interest in the Category 2 license whatsoever, as a matter of law. And we also have pointed out in our submission that Christopher Carney, as a matter of law, exercises no control whatsoever over the applicant. So we're prepared to discuss that in detail, but we would ask from a process point of view that we use today to talk about as many issues, many of those withdrawal issues that the commission and the IEB may have, so that at the end of today's process, we can eliminate any confusion or as many questions that exist as we possibly can.
Does that mean that you would want to move forward on the preliminary suitability report the IEB would present now? Or would you prefer to address the request for withdrawal first and at a later, but perhaps August 16th or 18th date?
I'm now concerned that the commission is going to consider a suitability report, as some have termed here, in a vacuum. And that the request to withdraw is, integral to our response to the IEB report. And I think, with respect to challenges around scheduling, certainly I think we have to, work with what we can here, but really paramount ought to be, at the end of the day, the due process of the applicant that's appearing before you. And what we're telling you is, from our perspective, in order for this to be heard in a way that I think not only makes sense, but certainly protects our interests, is to the sequencing of it. Again, back to the question of ordering, which we're trying to decide, of having us present and on the issue of withdrawal. And we had offered at one point in connection with this hearing process that if the commission so preferred, we could hear that and potentially, maybe deal with any other remaining issues in connection with the application. We don't, begrudge the IEB an opportunity to look at our documents that we filed, their finding of fact for the commission. It's ultimately the commission's decision on this. And if they need additional time to understand the steps that we've taken, the documents that support that, we would be open to an opportunity for the IEB to then do that, come back to the commission. I think then you could render a decision regarding in the first instance, the withdraw, and move right into the preliminary suitability decision. Again, we are not running from answering questions that are raised in the IEB report pertaining to the trust, pertaining to Mr. Carney. What we are saying is it's a fundamentally different review for the commission if the trust is in or the trust is out. And frankly, how we respond to it is also pretty determinative of that decision. So again, I think, what we're offering, we're not opposed to this being done in a multi-step process, as long as we can keep this moving. But that, from our perspective, is from the applicant whose due process rights are at stake here. That's what we think is the proper pathway forward for the commission to concern.
Madam Chair,
Yes, Commissioner Skinner.
would just like to pose a question to Attorney Nozel, if I may, and perhaps our legal counsel. Attorney Nozel, the problem that I see in what you're saying and proposing, the withdrawal petition is certainly the basis for that is grounded in fact, right? In terms of what you are asserting Chris Carney's role will be going forward. And it is that he will not have a role relative to the applicant. And he will no longer have a beneficiary interest in the trust. That's all fact-based. And so the question that I have for you and our legal counsel is, how should the commission be considering that when it comes to good cause? What are the factors that we need to be flushing out relative to those facts, and what the implications will ultimately be relative to the applicant and any other qualifiers?
So if that's directed to me, first, Commissioner, as the standard of good cause, it's a reasonable reason. It can't be something arbitrary. Here, what we've presented to the commission is that a matter of law, we have made substantial changes to the structure of our application that has eliminated the trust and therefore the beneficiary interest of Mr. Carney from the application, in addition to taking other steps to remove him from any managerial responsibilities. And we would take an additional step as well in connection with any loan matters that we're happy to get into if we're going to address this. So I think it's got to be something that is a good reason, and I think that we're able to demonstrate that particular standard as the basis for the request to withdraw, which is partly grounded in the fact that as a matter of law, the steps that we've taken really no longer make him a statutory qualifier for the trust.
If I may as well add a comment, I'm sure as the commissioners know, fact and law are usually connected or are always interconnected. But we have resolved the factual question concerning withdrawal by providing the legal documents that effectuate the actual legal step of the trust no longer having any connection whatsoever to this license or to the MGA. So you're absolutely correct. There's always a factual question, but those factual questions have been resolved by providing the legal documents that remove the trust from MGA. So as a matter of law, the subchapter S trust cannot enjoy a financial benefit should the commission issue the license whatsoever from that license. It's legally impossible. The only shareholder is Mr. George Carney. So there's no connection whatsoever any longer, legal connection between MGA and the trust. And there never was a financial connection between Christopher Carney and MGA and the license. Christopher Carney has never been an officer, director, employee. So we have taken those steps already, and we hope to be able to answer any follow-up questions that you may have about those steps.
And if I may, these issues around what has happened with the trust and then being characterized as now as a matter of law, Mr. Christopher Carney is no longer a qualifier. There are many other factors that are in existence as of today that show significant entanglements by Christopher Carney with this applicant. Some of them are financial in nature and some of them are non-financial in nature. As well, the changes that were put into place with the trust have now an impact that it requires additional review with how does that impact the financial suitability of Mr. George Carney, who has now taken, that document was just provided to us at 4 o'clock yesterday, may have significant impact on the rest of the package here. And, we've gotten into a number of facts here. And
Director Lilios, can I interrupt there? Because this is exactly the scenario I imagine. If we start going through this preliminary suitability review without knowing if they're in or out, we're going to continue like, well, if they're in, it'll be this, and we're going to be out, and then that. And it just seems, I'm having an issue with the efficiency, but that I can you know, I'm hearing Commissioner O'Brien saying she doesn't struggle with that. So Commissioner O'Brien?
I don't, because I think they're so inextricably intertwined. I don't see how we move forward without hearing it. And to go back to Council for Chris Carney's comments too, I appreciate and I trust in the veracity of the representation on Mr. Carney's availability. My point was the statutory obligation would evaporate upon his status changing from qualifier to no longer qualifier, which to me is key. There are absolutely due process considerations in this. It is a different posture they are in as applicant than the holder of a license. And so I think that there is a way to do this that honors what is appropriate for the applicant, what is appropriate for this commission to get in terms of the information we need to make the decision. I think we were queued up to hear the details of what was known up to this moment, up until a couple days before when they decided to make the move in terms of motion to request that he be withdrawn as qualifier. I think the most efficient thing to do is to move forward as we were scheduled to do today, which I think may then clarify how much we need to then circle back on what would appear to potentially be August 18th to hopefully bring this to a conclusion.
Madam Chair, at your, however you deem fit, I would like Todd to respond to my question, please, relative to the good cause.
Oh, yes, and I'm sorry. Did you want to respond to that question? Is that, I'm sorry, I might have misheard you.
When I posed my question, I posed it to both the Applicants Council and to MGC's legal counsel.
So you would like to hear from Councilor Grossman?
Yes.
My apologies for not circling back. My apologies. And I also think I had a question out to Councilor Grossman about the due process issues around this being a public meeting versus an adjudicatory hearing. And I think the fact that things are very intertwined. So first to Commissioner Skinner's question, Councilor Grossman.
Yes, thank you. As far as good cause is concerned, it seems to me that you have to view it through the lens of the statute and the regulation that talks about who and what a qualifier is. And I believe Mr. Nozel mentioned this as part of his remarks as well. The statute, it's section 5 of chapter 23N, talks about who a qualifier is. And we supplement that in 205 CMR 215.02, where the commission also talked about who the qualifiers are. And of course, you'll recall that section 5 was amended recently by the legislative process. You'd have to understand the facts of the matter in order to apply them to the law. And that is ultimately, in my estimation, how you would land on whether there is or is not good cause. And just to pick up on one of the things Attorney Maurizio mentioned, I'm not sure that all of the factual questions have been resolved. I think that's part of the point, is that the applicant has made a number of assertions and advanced a number of proposals to move forward, but those have not been vetted in any way to ensure that there's a complete understanding as to what impact they have and whether, in fact, they would completely address the statutory and regulatory questions as to who must be a qualifier. You'll also recall that there is some discretion in the commission's regulations that talks about folks who have a business association with the applicant becoming a qualifier and things along those lines. So it will be, in my opinion, critical to have a good factual understanding in order to make the good cause determination. And that's the lens that I would look at this request through. So let me talk about the adjudicatory proceeding question. The regulations don't specify that this is something that has to be looked at an adjudicatory proceeding. I'd want to just double check that. Certainly the applicant is not making that request, and I don't believe it's required. at this juncture. I think it can be addressed and has historically been addressed for what that's worth in a public meeting session. At this juncture, though, it seems like the threshold question is whether the commission is prepared to address the withdrawal petitions today or not, and whether there is further information that would be beneficial. At its core, the ultimate question is, how do we ensure that the commission is in the best position possible to make this to answer this question as to whether these two individuals and entities are qualifiers or not? Do you have all of the information you need to answer those questions before you here today? And I think that's the first question to answer. And then the second question becomes, based on that, do we want to move forward with the review of the application as has been presented on the agenda and as the IEB and others have already spoken to here today? It seems to me that there are certainly facts that are relevant to both questions. And so for the reason Mr. Nozel mentioned, as far as the decision not insulating MGA one way or the other, I think both or all of the options that have been presented are certainly legally viable, but it may be helpful to address this one issue at a time. And I think the first one to address is whether the commission is inclined to move forward today on the withdrawal petitions and go from there. It seems to me that that will be the best way to lead to some type of resolution of this procedural question.
Before we move on, I think Director Lilios, can you tell me were the three decisions that were forwarded to us, weren't they all in adjudicatory hearings? They happen to be publicly held but adjudicatory hearings.
They were, Chair. They were, Chair. They are still instructive to you because what they did not do was decide whether there was good cause for withdrawal as a separate matter from suitability. So they, you know, the Our Way case, in that case, the investigation showed that there were some financial improprieties by the head of the company. And after the IEB's report was filed, the CFO of that company resigned and asked to withdraw his application. The commission noted that the offending practices were not detected by the principals of the company until the IEB report was filed. The CFO resigned after the IEB report was filed and the case was scheduled for a hearing. And even though the CFO resigned from the company before the hearing and had cut all ties with the company, the commission considered his request to withdraw in the context of the company's suitability at the suitability hearing, not as a separate related matter. The commission in that case recognized that the CFO was not an island to himself whose qualifier status could be decided in a vacuum, because the circumstances related to the CFO were reflective of the business practices of the company and were integrally tied to the applicant's business practices. And that is what the IEB is concerned about here, that the issues identified in the IEB report as having to do with Mr. Christopher Carney all occurred over a lengthy period of time in the IEB's information under the eyes of the applicant and are reflective of the business practices of the applicant. And that is a statutory suitability criterion, the business practices of the applicant. The applicant in Our Way, the overall suitability in the withdrawal motion were considered as part of the same decision of the commission. There are a couple other instances where the commission has decided on a withdrawal of a qualifier. Notably in the Steve Wynn case. In that case, procedurally, quite different because that company already had a license. The company was already found suitable in that case. And the core things that the commission looked at there was whether Mr. Wynn still had entanglements with the company. And then in a Rolling Hills matter related to the MGM Springfield application, there were 2 individuals and an entity involved that had no management, no ownership in the company, but they had a residual contractual arrangement with the company, and that was actually handled after the full suitability decision of the company. I think the facts were mostly gathered together. Full suitability was decided. So the IEB's view is that the issues of significant investigative concern that were identified in the preliminary report go directly to the business practices of MGA, and whether they were able to detect these issues, whether they had the interest and the focus to address them, whether they were concerned about another regulator and their responses to another regulator over the course of years. And that is really why on this statutory suitability factor of business practices, that the IEB feels that these, the withdrawal matter is not something that should be decided first and then as not part of the overall preliminary suitability decision.
Chair, if I can respond. Briefly.
That would be helpful.
Yeah, the IEB's concerns that they just outlined aren't part of the report. They're not in front of the commission. I'm not suggesting that they're not areas of inquiry that the commission may have at this point, but it appears now that the scope of the IEB request, the IEB report, is expanded. And if I can respond briefly on Orway, Wynn, and Rolling Hills, I think those are all 23K cases, and they're all were done in very different circumstances. And we would suggest that the business practices in Connect were at issue in our way, specifically in that particular decision, the business practices, including the conduct of the CFO. There's nothing in the report that's before the commission that challenges any specific business practices on behalf of MGA or the other applicants. It all pertains to Mr. Carney in connection with unrelated businesses. Second, in connection with Steve Wynn, that actually occurred exactly the way that we're asking for. It was a determination on his suitability and whether or not he was in or out for purposes of the company's ongoing suitability, which was determined after the fact. Third, in connection with Rolling Hills, that situation actually, the commission went forward and granted MGM its preliminary suitability finding and actually put the Rolling Hills piece in a box and dealt with it completely separately. So all of these cases do not stand for the proposition necessarily that the commission has to consider a request to withdraw in the context of a preliminary suitability finding. And again, we are in a very different posture, which I will admit presents a challenge of having to deal with these issues and a request to withdraw in this context of a preliminary suitability decision. What we're attempting to do is to try to narrow the issues that are going to be in front of the commission for the purposes of that determination. Again, not avoiding any area of inquiries, any area of questioning that you may have as it relates to MGA. And we're attempting to work within the processes that we have, and there is nothing in the regulations that provides for an adjudicatory hearing in connection with a request to withdraw. In fact, request to withdraw only comes in front of the commission at a certain stage, and we happen to have triggered that. apparently, I think the language of the rule is actually a little bit ambiguous. There are certainly requests to withdraw, and there have been withdrawals of qualifiers prior to that ever coming to the commission for any determination. So there are a lot of different avenues in order to essentially address an issue regarding potentially regarding suitability by the removal of a qualifier. And we feel like in this particular case, we're working within the process that we have, and we think that it's an appropriate, in our mind, solution to the questions that have been raised in connection with the IEB investigation. And we do feel like if the sequencing of this and the process by which the commission makes this determination, if the IEB needs additional time in order to review the documentation regarding sort of the withdrawal, we understand that. But to go forward in any way with the IEB report without either hearing the motion to withdraw or preferably deciding it really does put us at an incredible, I think, disadvantage in being able to present our full application for the commission's consideration.
Pastor Nozel, thank you for that. I need to request a short break. And so if we could, it's 11:30 now, if we could return in 15 minutes. I just need a break, and I bet my fellow commissioners will be okay with that, correct? Thank you. Thank you very much. Okay, Dave, thank you for taking down the screen.
All set.
Thanks, Dave. Thank you very much. And thank you to the commissioners for allowing me that brief pause. I think I've got everyone. This is the reconvening of the Massachusetts Gaming Commission's public meeting, number 469. After a brief pause, and because we're holding this meeting virtually, I'll do a roll call. Good morning again, Commissioner O'Brien.
Good morning. I'm here.
Good morning again, Commissioner Hill.
Good morning.
Good morning again, Commissioner Skinner.
Good morning.
And good morning again, Commissioner Maynard.
Good morning.
I did want to turn back to Commissioner Maynard and Commissioner Hill because we haven't heard from you and of course the other commissioners, but I wanted to turn back to you. But and I don't know, I think Councilor Grossman, in terms of the legal framework, does it make sense to do any reminders now, or should we hear from Commissioner Maynard and Commissioner Hill?
Absolutely. I think we should hear from any commissioners who have any further comments, and then I'm happy to offer a few thoughts.
Okay, thanks so much. Any comments from either of you, and then Commissioner Skinner and Commissioner O'Brien, if you want to weigh in or react or add in. Commissioner Hill?
Thank you, Madam Chair. I really have not changed my opinion from my earlier remarks. I still feel as though the request for withdrawal, we should be getting some further information from IEB and others. And certainly I would want a little bit more time to digest the request. And I am still fine with moving forward with hearing parts of the application today, even if it's the diversity piece, something, so that we can move forward.
Yeah, we're definitely going to do diversity, Commissioner Hill. And are you comfortable moving forward in addition to diversity? Well, we'll have a vote on it. So, but
the answer is yes.
Yeah, that's what I thought. Thank you so much. Commissioner Maynard.
Well, first of all, I feel like this has been a really long conversation about process and about order of operations. And I feel like any positive to hearing this matter the way the applicant wanted to is totally negated by the fact that a lot of issues have been raised here. And I think that it's only indicative that this is a really hard matter to separate. And, you know, the day that the applicant applied for a license is my understanding is the world in which the IEB was working on when they produced the report. Sounds like there was a timing issue on when the applicant started thinking about maybe removing a couple of folks from the organizations, but then it came in on Thursday. And I think that the IEB should have every right to be able to answer that report or answer that request or have something written for us. And I want to have the process that the applicants do. My understanding is, by the way, as far as due process goes, the applicant can question any matter of fact or analysis that's in the IEB report as it stands, right? So the assertion that they won't have the right to do that, I think is I just want to clarify that I would expect them to do that. If there's a factual or other issue in the report, I would want to hear about it. But I also have to think about 38 section 20 and what's owed to the public and what we as a body owe the public. And, you know, we have to think about that and we have to weigh that too. And like I said, you know, we can't have sidebars, right? So I can't pull aside somebody and say, this is what I'm thinking. I have to do it right here, and I'm doing it. I think there's been a lot of questions raised that if we would have just done the report 2 hours ago, had the applicant respond to the report and then moved on to when we were scheduling the request to withdraw. I think if we would have just done it that way, this would already be over. Instead, we've done this for 2 hours and we're still nowhere. And that's what's frustrating to me. So that's where I am. I don't think you can divorce these things. I hear what the applicant's saying. I'm trying to respect the applicant. I don't think the report can be divorced from the withdrawal motion.
Okay, I'm going to then call the question unless I'm hearing anything further from Commissioner O'Brien. Commissioner Skinner, we did mark this up for a vote as to the order of matters. Do I have a motion?
Certainly, Madam Chair, I move that the commission move forward with the presentation from IEB on the suitability question on the applicant as noticed in the agenda.
Second.
Can I have a friendly amendment? Can it, I believe that IEB Director Lilios indicated that there would be no vote on at the
Correct.
conclusion of that review.
It's simply the presentation.
Is that an amendment?
I can certainly move. I move that the commission move forward with presentation by the IEB as originally noticed on the agenda for today, reserving any supplementation by IEB or adjudication by vote on the question of suitability and the question of the motion to withdraw by a qualifier.
Second.
Commissioner O'Brien, can I ask clarification? Does that mean that there will not be a vote at the, you said reserving, does that mean?
Future date, for a future date.
For a
Yes,
future
there's no vote today. To make it clear, no voting is expected or would be moved on today.
Thank you. And then a second, Commissioner Hill.
Second.
Thank you. Okay, Commissioner O'Brien.
Did you open this up for discussion?
Oh, yes, I'm sorry.
Nope.
Any discussion, further discussion?
I would be okay with moving this to a future date. I just want to get this on the record. If we still allow the original report to be presented first at that future date, I would be okay with that. I just want to put that on the record and throw it out there for discussion.
I'm going to turn to Councilor Grossman. If it were put on for a future date, how does that, what does that preserve for the applicant or IEB?
Well, I think the obvious piece is that it would offer the IEB an opportunity to prepare a written response to the petitions to withdraw so that
No, I think you're saying you would roll over the hearing on the petition, on the preliminary suitability report for a later date. Is that right, Commissioner Maynard?
What I'm offering up here is what I think to be a compromise, which would be that the future date allows for the IEB to put together a response, a written response. But I do not believe that the issue should be heard before the IEB has the opportunity to present what was in the initial report. So my suggestion would be on that date, we would go forward with the initial report. The applicant would have an opportunity to respond to that initial report. Then the applicant would be able to submit, or we would then have a hearing on the applicant's request to withdraw. And that the order of operation would not really change, but it would give more time. And the reason it's a compromise is because I think IEB is ready to go right now on the report. And so the compromise would be the IEB has to wait a little while to go on the report, but the applicant would still have to answer that initial report in a public forum as so much that it's required. And in a private or executive session in so much that that's allowed.
Madam Chair, question or comment and question, I guess. Attorney Nozel indicated earlier that the applicant is at a significant disadvantage in moving forward with the preliminary suitability presentation. Wasn't clear if it was the presentation itself or a vote on the suitability today. And so just wondering if we could turn to the applicant for a response to what Commissioner Maynard just put on the record.
Mr. Nozel, Mr. Maurizio?
Yeah, so I'm gonna begin. So obviously our preferred and what we think is the appropriate pathway forward is to hear the motions, or excuse me, the request to withdraw and then move to the suitability finding. I'm not hearing a lot of support for that, certainly amongst the discussion that's happening in connection with Commissioner O'Brien's motion. I think everybody here has agreed that these two things are intertwined. I think that's the word that's been used. So they should not be heard on separate dates. So one major concern I would have is if there's a proposal to go forward with the IEB report today, and then the request for withdrawal doesn't get considered or even presented to the commission for another 2 weeks. So if the commission is inclined to, I guess, and maybe what Commissioner Maynard is proposing, that these two things be heard together, that should either be done today or should be done at a future date. We're happy to cooperate with the IEB in providing any additional documentation regarding the withdrawal, its impacts, and essentially at least to address the IEB's factual concerns to the extent there are any pertaining to what we propose. But at a minimum, I think in fairness, that these two things, to the extent that the commission wants to hear them together, ought to be then heard on the same day, not separated by a 2-week period.
Can I ask, given this discussion, if we can withdraw the motion to just, or
Respectfully,
you're going to
I-
keep your motion on? Okay.
I'm going to keep my motion. There's a second. I want an up and down vote on it. And in regards to that, having spent years as a prosecutor where grand jury and trial presentations were made over the course of days and weeks, I have every confidence that we could, for efficiency's purposes, go through with what was on for today and go forward without prejudice to anyone. It would give time to the IB to respond and keep the ball moving forward. I don't think it's prejudicing anyone, but I don't have a problem at all just moving forward with the vote. And if the vote of the body is to delay until the week, 2 weeks out where we hear it all together, then so be it.
Are we still under discussion?
We are still under discussion.
If I could just respond quickly to Commissioner O'Brien's comments. If there is a pathway forward that the applicant is saying is better for it, for purposes of its rights in connection with this process, and I'm unaware of any sort of prejudice to the commission, and in fact, it gives the IEB an additional opportunity here to provide additional information to the commission in connection, again, what it says, a consideration of all these issues together. I would think that would be the appropriate pathway forward, as opposed to simply making a decision based on process.
Respectfully, Attorney Nozel, what I've heard so far from the applicant is a continued desire to hear the motion to withdraw first, and then moving forward on what was prepared to be presented on suitability with any supplementation as may be necessary based on the most recent submissions by the applicant. If what this applicant is now saying is a request to continue to be fully prepared to do all intertwined at the same time 2 weeks out, that's a very different posture than what we had been hearing. I still think it would be an up or down vote on the motion that I had, but that certainly changes the procedural posture that was put forward by the applicant.
Commissioner, responding again to what I sense is the desire of the commission to both consider these issues together ultimately when they vote, and to hear the IEB report first. If that's the direction that the commission is going in, then what we would suggest is that all be done together with the benefit of the additional information from the IEB, our opportunity to provide the IEB additional documentation to potentially address any of their concerns. And we just do that all on the same date that's been proposed by the commission. So my suggestion here is dealing with the reality that the commission is not going to accept what we're proposing. And I am too offering, again, respectfully as an applicant before the commission, a compromise, which I think is certainly more fair to us, and I still think meets the commission's goals.
If I could add in, if I were a moving party, I would have moved to go forward first with the review of the notices to withdraw, just because of efficiency and the way my mind works around these issues. I've heard both sides. I've been thinking very carefully about it. I do think we offered IEB the opportunity to get some more time in order to be able to respond to the motions that came in writing to us on Thursday. Quite frankly, I think that that's smart. I think we should have the benefit of IEB responding. I also think today raises, I'm sure, some questions for the applicant. And quite frankly, I would offer them the opportunity if they need more time. So I do like the fact that Commissioner Maynard, even though he did indicate that this was 2 hours too long a process, it is a very involved process question. And so to the extent that the applicant would want some more time in conceding the order of events, I support that, so that we can all make sure we're hearing everything. That's my theory. We could vote on order today and allow for this all to come before us in a streamlined fashion with both parties being heard fully. Commissioner O'Brien, I hear your motion, and I know it is live, and I know we have to call the discussion at some point, but I want to make sure everybody's being heard. Commissioner Maynard.
I'm sorry. I just want to know if the IEB, I heard that the applicant said they're okay with a quote unquote compromise. Would the IEB be okay with that? Again, assuming that the order of operations is the way that the IEB has requested today, just on a different date. I would like to know that.
Commissioner, thanks very much for asking. You recognize the IEB is ready to go forward on preliminary suitability today. We do have a team approach. We've assembled the team today. They're all ready today. But I understand all of the different interests that you're weighing. Did feel strongly about that order of discussion. This opportunity to respond to the motions in writing, we think is important, and we would review the various documents that are being submitted even as of this morning that would be related to that motion. I see that my view is that this would not be a further investigation that we would perform over these next couple weeks. We would be responding to the motion, but not, opening up new investigation. So, if you decide to go forward at the later date in the order that Commissioner O'Brien's motion stated, of course, we will be ready for that.
Further discussion, Commissioner Skinner?
No, I'm sorry. I didn't realize I was unmuted.
No problem. Thank you so much. Councilor Grossman, I'm going to turn to you. Any reminders on legal framework issues that we should think about before we take our vote?
I think the commissioners have just hit on all the marks. I think the applicant has had an opportunity to express its view, as has the IEB. depending on the outcome of the decision, I may have a few additional observations to share, but I think it's both Commissioner O'Brien's and Commissioner Maynard's proposals are viable and legally tenable. I don't have concerns with certainly either of those. Ultimately, we're just looking to ensure that the most equitable process is in place. And I know everyone shares that interest. So I think, yeah, calling the question, I think makes sense. And depending how it goes, I may have a few additional thoughts.
Okay. So I have not started to take the votes. We've called the question. Commissioners are all set.
So I
Commissioner-
guess
Oh,
my
sorry.
only question would be for Commissioner Hill. I'm still fully prepared to go forward as I drafted the motion and presented it to the body. Given the current status and what appears to be the consensus that continuation would again start with the presentation by IEB on suitability and then go into what we have deemed sort of inextricably intertwined the motions to withdraw. I would consider amending the motion to bump that out to the date in August that I believe Grace threw out. But I did want to hear from Commissioner Hill. We have not heard from him in this discussion.
I was more than happy to move forward with the original motion, but if you want to amend it, I certainly would listen to it and support it.
Okay. Given that and discussion, Madam Chair, I would move to amend the motion that the commission move forward on the presentation by IEB on the preliminary suitability report that it is drafted and presented. And also at that same time, after which the commission will take up the issue of the motions to withdraw by the qualifier, Chris Carney, and the trust that were presented, and that those matters be continued for no longer than, I think, August 18th, 2024,
I think it's
2023,
I think it's the 19th.
19th.
No, that's a Saturday, I think.
Yeah, I think 18th is the Friday.
Yeah. The 16th was out there, but I think it might probably that Friday on the 18th, if that works for everyone.
I think I'm just doing that as the outer limit. If we
The
can do
outer
the 16th, we can do the 16th. but
Or-
that
or-
gives us-
Or even earlier, you know, if we
Correct.
find miraculously sometime before.
Correct.
I second that motion.
I don't know if Commissioner Hill has to, since he seconded it originally, or
I think I do, and I would second it.
Any further
Because we were amending the.
we're
the
amending,
original.
right?
It's fine. It's fine.
Sorry, yeah, it's fine. No issues. I thought you withdrew.
No, amended.
No problem. Further discussion. Okay. Commissioner O'Brien,
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner,
Aye.
Commissioner Maynard.
Aye.
I vote yes, 5-0. Okay, to the applicant, this has been, as Commissioner Maynard pointed out, a long discussion on process, but an important one. And I think for both IEB and the applicant, it gives some important time for all. We did, commissioners, have in front of us the submission on the diversity plans that we had requested at our last hearing. Do we want to move forward on that today? We could under our agenda, or if you'd like to roll that over to our future hearing, we're happy to do that. But I just want to, you know, Commissioner Hill noted, like I had in my mind, we could at least move forward on that to so that issue may be fully resolved. Commissioners. I'll turn to the applicant next too.
At this point, Madam Chair, I think we should just move it to the next meeting at this point.
I was getting nods from some people in agreement with me, and now, okay, so you're saying move it forward. I'm just going to do a little, first off, I'll turn to my fellow commissioners first. Yes on diversity now, or wait?
I would agree with Commissioner Hill at this point
Okay.
to just move it.
I'm worried about how long this could be. when we start to have this conversation on the 18th, not the 19th. And so I would go ahead and hear as much as we can and just leave that open to suitability. So I would do it today.
Commissioner Skinner, how do you feel?
I'd like to push it to the 18th.
Okay. Sounds like we have a consensus to push it. I would have done it too, just so that we could check it off the list and not have any questions, but sounds as though 3 want to push it. To the applicant, we appreciate your patience. To IEB, we appreciate your patience. This is not uncomplicated and we want to get it all just right. Now I'll turn to Councilor Grossman for any words of wisdom and advice that you can give us as in advance of our next hearing so that all expectations are set.
Certainly, we want to ensure that there are no surprises for anyone. So we will ensure that all materials that are being prepared will be shared with certainly the applicant and the commissioners, and we have a very clear process in place. But I think otherwise the questions have been largely resolved for today. We will take a close look at the process and make sure that it is all in alignment. We have a little bit more time to do that in light of today's conversation. So we will, of course, prepare the agenda for the next meeting and go from there. But I think otherwise the commission has spoken on this matter and we'll be ready to go on the 18th.
Attorney Nozel, Attorney Maurizio, any questions?
No, Chair, we appreciate, certainly the commission's time today and appreciate the thoughtfulness that they've approached the issue. And, we do plan to reach back out to the IEB in very short order in order to provide any additional documentation or information that they may need in connection with their review of the request to withdraw.
Okay, Director Lilios, are you all set? Councilor Hall, are you all set?
All set, Chair. Thank you.
Thank you, Chair. Okay. All right. The only request I would make is for us to consider to look at our schedule because the motion was as late as August 18th. So we'll look at the calendar and then, of course, work with IAB and the applicant to see if we're able to move it up. I know time is of the essence in this matter, so we'll continue to look at that schedule very, very carefully.
And Chair, we'll make our team available to the extent that the commission has any earlier opportunity. We will make that happen.
Okay, commissioners, maybe you will just be able to work very closely with Grace and Trudy on any options and flexibility on your calendars. Okay. Thank you. Am I correct then, Attorney Grossman, that at this point we look for a motion to adjourn?
Yes, I think that's.
Yeah, commissioners, you don't have any other business. All right, I'll take a motion to adjourn.
Move to adjourn.
Oh, I'm sorry. I thought we were continuing. This is a continuation of the original hearing. These are called individually.
Oh, I think we've adjourned. I don't know, Councilor Grossman.
Yeah, since it's a public meeting, I think it needs to be adjourned.
Okay.
It's not an adjudicatory proceeding.
It's not an adjudicatory hearing.
Okay. Then move to adjourn.
Second.
Just a matter of, I think, clarification on our agenda. We always post the public meeting, but we do note what has occurred before, and then we roll it over into the agenda. We've been pretty particular around that. Okay. So we've got a second. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
And I vote yes, 5-0. Thank you, everyone. Have a good day.